I think we can begin. Good afternoon. My name is Mohammed Abduroaf. I'm a practicing advocate in Cape Town. I'm connected to a company called Our Lawyer Pty Limited, and Our Lawyer Pty Limited has a Facebook page, and on that page we try to promote various legal topics so that we can inform the public about various issues that you might face. And hopefully, if you find this video useful or beneficial, we ask if you can kindly share it. This video is streaming live on Facebook on various platforms. So if you do not want your face to appear in this video, please mute your video. Later on in this video, we might have one or two people speaking, and you're welcome to pose a question if you wish to do so towards the end of the video. Firstly, this is a free webinar, so if you have posted questions previously, sorry, for the last day or two, I have recorded those questions in a spreadsheet, and I've placed it into a PDF document. So those questions I'll deal with. If at any point you wish to pose a question live, you're welcome to do so. I think we can begin. The first thing I'll do is I will place on the screen the questions that were posed. Those are the questions. I hope you can see it. Those people watching this video via the Facebook pages, the live stream, unfortunately you won't be able to see the screen which I can see and the participants can see, but hopefully you can listen and be able to follow. Firstly, thank you for partaking, all those who are here today, and I hope you will benefit from this video. So today's topic basically deals with the issue concerning child custody and parenting plans. It's a very interesting topic, and I would say also a serious topic, because when it comes to the issue of parenting plans, it means that the parties cannot come to some type of an agreement regarding their contact rights, their care rights, etc. towards their minor child. I won't go into much detail of the law because many people do not understand the law, and that's why they actually watch these videos. I believe many legal practitioners, they focus too much on mentioning the Children's Act, mentioning the Constitution, mentioning various pieces of legislation, which nobody really understands, or those who do understand it are basically lawyers. So I'll try to follow a lay person's approach and try to advise you accordingly. So let's begin. What is a parenting plan? So a parenting plan is an agreement which you have with a co-holder of parental rights and responsibilities, basically with the other parent, whereby you guys come to an agreement regarding your contact rights, your maintenance obligations, guardianship issues, basically when you can see the child, when you can't see the child, matters concerning school holidays, extramural activities, etc. So it's a plan which you have agreed to with the other parent in how you two are going to be the best possible parents for the child. It's very important to note that. It's not a document which is templated in the sense of one document fits all. It doesn't work that way. You and your child and the other parent are best fitted to decide how you are going to parent your child. All kids are different, ages, preferences, needs, etc. Therefore, we can't say that one parenting plan fits every single parent or every single family situation. For argument's sake, a child might be 17 years old. His or her needs will be different than a child of 15 years old because the 18-year-old child is in matric. And at the same time, parents might live in different suburbs. One parent might live in Cape Town, CBD, the other parent might live in, for argument's sake, Belleville, or in different provinces as well. So there's no one parenting plan fits all. That isn't how it works. Basically what we are saying over here is, let us look at the situation, let us look at your specific family, and what's the best way to, to plan ahead with regard to caring for the child. So the quick example which I like doing is, I would say, if a client comes to me and say, look, let's work from Monday till Sunday. What do you suggest happens on the Monday? Does the child wake up at your place, or does the child wake up at the other party's place? Who takes the child to school? Do you take the child to school? or does the other party take the child to school? Who collects the child from school, and who does the child sleep the Pacific evening? So those are the questions you have to ask. So you go up until the Sunday. Then we go into the issue concerning birthdays. What happens on the child's birthday? Does the mother have the child during the morning? Does the father have the child during the morning? Or what if the birthday falls on a public holiday on a weekend? What happens then? Then we're dealing with Father's Day, Mother's Day, what else is the religious days, Christmas, Eid, and various other religious holidays which various denominations would have. Then we deal with issue concerning school holidays. You know, does this child stay with you for the first half, with the other parent for the second half? Does the child continue, you know, with 1 day on, 1 day off? Is it 1 week on, 1 week off? No, that has to be discussed. I'm just being general here. So we come to a scenario whereby we plan a parenting document for an entire year. We might change it as we go along. Maybe when the child is 6 years old, we'll have a certain type of parenting plan, not allowing, for example, sleepovers during the week. Or alternatively, when the child gets older, maybe 10, 12 years old, then we might start implementing a certain type of, you know, midweek overnight contact, if it's in the child's best interest and it's possible and it's workable, etc. So remember, if you're going to ask me, how should a parenting plan be drafted or what should it entail, I will start off, let's start off on the 1st of January 2021, and let's move on to the end of the year, or the 1st of January 2022. And based upon that, we can work something out. Obviously, a parenting plan will have various, you know, falling on clauses. For argument's sake, if the parents cannot follow the parenting plan for a specific period of time, a typical example would be COVID-19 with a lockdown. Kids were at home for many months, where previous years kids were at home only for a period of a month, and you shared the school holidays. So those are the complicated issues that might arise. Or one parent will have to go away for work purposes, or one parent might remarry and go on with his or her life, and there will be like a change of a abductness in the specific parenting plan. But be that as it may, there needs to be some type of flexibility. So we will have in maybe a facilitation clause in there stipulating if the parties cannot agree upon a certain issue concerning parental rights and responsibilities, for example, a specific school holiday, an important event like another parent getting married, because one parent might say, no, that's my weekend, the child can't be in your wedding because it's my weekend. I think that's being a bit unreasonable. But if that is the case, there should be a clause in there to stop the parties from, firstly, arguing these specific issues, and secondly, trying to resolve these issues without going to court. So that's where the parenting plan has to deal with those issues. So on the whole, a properly well-drafted parenting plan would be a document, I would say, of no less than maybe 10 pages, you know, dealing with those specific scenarios, especially the issue concerning dispute resolution, because you cannot go to court every single week or month because there's a problem. And things happens, and it always happens. And as I said earlier on, the reason why we have a parenting plan is because parents cannot come to an agreement regarding these specific issues. Then later on, you'll see a few questions being posed where the specific participant would ask a question regarding how can she get or he get sole custody over the child. Now, custody, guardianship rights, care and contact, those are very nicely stipulated on paper. You know, you go to a lawyer, he draws something for you, you go to court, the court draws something, etc. But these are real people, you know, real human beings, children's lives. So you can't necessarily, you know, deal with these things only on paper. We need the parents to be responsible, to be reasonable, because the law cannot always come to your assistance in resolving these issues. So if the mother is adamant, she believes she controls the child, she believes she owns the child, she believes that the father's rights to the child will be only limited as to what she can, you know, dictate to the father because she gave birth to the child, and the father was most probably not involved in the child's life for a lot of time. Maybe because that was by his choice, or maybe because the mother didn't allow it, as the case may be. I'm just dealing with the scenarios which comes to my desk on a regular basis. And at the same time with the father as well. You know, many fathers out there also, they have not done their responsibilities, towards the child. But that's the past, and let's move forward. That's always my motto in dealing with these type of matters. People come to my office regularly, and they like to badmouth and talk bad about the other parent from 10 years ago until now, which is fine. You're welcome to do that. You're paying for the time, but it won't assist us going forward, because the court is concerned what's best for the child, and what's best for the child is going forward, not going in the past. So a scenario that applied where the child was 1 year old and now the child is 10 years old, things have changed. Parties have remarried. I do not necessarily want to listen to what happened 10 years ago. I want to hear what happened just prior to you coming to my office, because that is most probably relevant. So if a party asks me, I would like to have custody over the child because he or she has been caring for the child for the last 10 years, the other party only sees the child once every 6 months, once a year, and now he or she wants sole custody for the child. I understand what the person wants, but maybe the term used is incorrect. You are already exercising basically sole custody over the child because the other parent is not really partaking in the child's life. So you're basically the sole custodian parent of the child. However, what you are maybe referring to is the issue concerning guardianship rights. Because whenever you go to the school or you go to the doctor or you fill in a document, it keeps on asking you, where's the other guardian? Where's the other parent? Are you a sole guardian, etc.? So matters concerning, for example, the application for a passport, for the relocation of the child, some important operations, etc., leaving the country, those specific situations, you require the consent of both guardians for the child. I'll deal with the issue concerning guardianship shortly. So you might not say, maybe your question should be reposed. You should ask me, how can I get sole custody for the child for the sole reason that the other parent is not available, is not much involved in the child's life, but every time I need to do something legally, for example, enrolling the child to a school, going to the doctor for certain procedures, medical aid, passport, going on holidays, I require the consent of this other person that does not care about the child, who is not involved in the child's life at all. Under those circumstances, your application would not necessarily be for sole custody, because you're already exercising it. Your application would be for sole guardianship, whereby you approach the court and mention to the court, I'm having this problem all the time. I have to always confirm with this person that's not involved in the child's life. Please give me the authority to make sole decisions regarding guardianship aspects. So that's where we're going towards. Now, does it mean that you are the parent of the child? You are the father of the child? Automatically it means that you should be consulted all the time? Does it mean that? Does it mean that automatically you have a say in the child's life at every specific point in time because you are the father of the child? Because you are the father of the child, you were involved in the child's life for the first day, but then you went missing, or you were never involved in the child's life, and now you come back into the picture 5 years later, and now you want to come and say, I would like to enforce my rights as the father of the child. The law is very concerning about the child. So it does not mean that you are the father of the child, automatically you have certain rights to the child. It doesn't mean that. If you were married to the child's mother, automatically you have those specific rights. But if you were not married to the child's mother, what happens then? Then you can acquire these specific rights of parental rights and responsibilities over the child, meaning contact rights, care, guardianship rights, etc. And how do you do that? So if you were involved in the child's life since birth, you pay child maintenance, you partake in the child's life, etc., automatically, by default, in terms of the Children's Act, you automatically have parental rights and responsibilities towards the child, meaning you're in the same position as if you were married to the mother of the child, or you divorce the mother of the child. But if you were never involved in the child's life, and all of a sudden, now you're back in the picture and you want to have a say in the child's life, no. You have to acquire those rights. You need to start getting involved in the child's life, pay child maintenance, to have contact rights with the child. If the mother refuses your contact rights, for good reason or bad reason, we advise you to approach the court to enforce your rights. So I think you basically understand where I'm going to here. I'm not mentioning law and all those things. The law is there to guide us, to put us in a proper path. If you're getting divorced, you don't go to the criminal court, and if you committed a crime, you don't go to the, to the tax court unless it's a tax crime. You go to the divorce court or you go to the high court. At the same time, if you're involved in a motor vehicle accident and don't claim money, you're not going to the divorce court, you're going to the civil courts. So that's where I'm going to with a specific topic. So let's move on to the questions that were posed, and hopefully we can get some answers regarding that. So thank you for those who have sent questions when you registered for this webinar. On this point, if you have an organization, a group of people that want to specifically have a webinar to discuss certain family law issues, you can speak to our lawyer and we can arrange it at no fee, of course. It's our way of giving back and educating people. But you're welcome to send us an email and just, motivating it, so we can have a group session, private group session via Zoom, and we can try to, empower and educate people in that specific manner. So the first question which we got, the person that registered first on our online platform, was, what can you do if the co-parent won't compromise and a parenting plan can't be finalized? What if high court is not an option due to cost? So this is where I'm going to with a parenting plan. Nobody has an obligation to sign a parenting plan. Let's say, for argument's sake, the father wants to have custody over the child and sole guardianship rights over the child. Meaning he wants the child to stay with him and he wants to have the final say of the child. And he wants a mother to agree upon that in a parenting plan. Clearly the mother won't agree to it because she believes that she must have primary care or, sole guardianship rights or custody over the child, as the case may be. So there's a dispute. The parties can obviously go to a social worker, maybe the family advocate's office might get involved, see a psychologist, psychiatrist, an attorney, advocate as well, to assist them in entering into a parenting plan. But if the parties are loggerheads, where the mother wants the child to stay with her during the week, and the father wants the child to stay with him during the week, a parenting plan cannot be entered into. I can't see the possibility thereof. Under those circumstances, unfortunately, you will have to proceed with the matter in court. You will have to have the judge hear you, hear the father, hear the mother, and the court will have to make a decision as to what is best for the child. You cannot force somebody to enter into a parenting plan. I think that will be irresponsible, and I don't think it will help anyone. We won't get far with that specific matter. If you force somebody to enter the parenting plan, more than likely that person will come back to us or to the court a few weeks later and saying, sorry, it's not working out. I was forced to enter into this parenting plan. Now I would like to, fight for what I believe I'm entitled to or what is in the child's best interest. So this is a warning to everybody. Don't enter into a parenting plan unless you believe that you can live up to the parenting plan. If you cannot, take the matter to court and let the court decide. Then the person asks, what if high court is not an option due to cost? There's the children's court. High court is obviously cost because you get attorneys and advocates on board. If you yourself can do the matter alone in the high court, then there is no fees applicable. The court doesn't charge you anything. However, there is a children's court and they'll be able to assist you as well. The second question. You can read the question, but it says basically, father of 3 and I have not seen my children since she left. My ex left, leaving the kids just before Christmas, returning after 8 months. Have been to family court and have not got anywhere, even though the family advocate ordered my ex to. That's why we ordered the ex to let him have contact. My ex-wife refuses and she says I must pay, and even then she still did not permit, I presume, for him to have contact. Court system, I have not gotten anywhere today, and 2 years, and have not contact at all. What should a father do? My advice to you is simple: go back to the children's court. I get this queries many times with people. They go to the children's court or to court and they don't get specific results. Then they get lawyers on board and then we get them some type of results. Not because we are lawyers, but because we were persistent in the children's court. The courts don't necessarily treat you better because you have a lawyer on board or because you are a lawyer. We many times have to stand in the same queues, so wait our turn. So the specific person you were at court. The options, of course, are to appeal and take it on a review, but I don't think the court made any decision. Go back to court, make some noise. If they do not listen to you, go on the higher level, speak to the court managers, speak to the senior magistrate, etc., and let your matter be heard. The third question: as a primary caregiver, I have my 7-year-old child during the week to establish a routine and structure, in particular schooling, from Monday to Friday, and share the weekend with his father. The father recently got married, requesting time during the week, and it's not convenient over the weekend anymore to spend time with the child. Also, his spouse has a child who goes to the father over the weekends. Do I have the right to contest the request on the basis to keep schooling structure, as schooling was never priority for my ex? I'm just mentioning that these questions are basically cut and paste from the registration form. So I don't spend time, rehashing it, because I think it loses effect, and then it's not my. Then it's my version of the question, not the participant's version. So regarding refusing or opposing the child staying with the father during the week, can the mother do that for schooling purposes? It's a very difficult question to answer, because is it her job to solely make decisions regarding what's best for the child? Because the father is also involved there. Will it be that detrimental for the child to go to the father during the week to have contact with the father? My view on the matter is the parties need to sit down. At the end of the day, the child needs to have both parents in the child's life. If the father wants to have contact with the child during the week and schooling is an issue, they must work around that. They must try to make it workable so that the child's school is not being suffering, or for lack of a better word, neglected. So if the mother is concerned about that, she has also at the back of her mind also remember that if she limits the child contact to the father, and the father only sees the child now for 8 days per month, sorry, not 8 days per month, 5 days per month, meaning every second weekend, the child could in another way also be traumatized or lose out specific contact with the father that he could have had. My advice for the specific mother is sit down with the father, try to work something out. I am a full supporter of parents sharing the child as much as possible. If we have the father and is willing to have contact with the child during the week, why not? Let's make it happen. But obviously, if it's not in the child's best interest and it's not workable and the child's schooling will suffer, then it's not a good idea. But it's not for the mother specifically to decide that in isolation, or the father. They need to sit down. If the mother believes it's not in the child's best interest, that is fine and good. Then my advice to the father is take this matter to the children's court. Let a third party, either the children's court or a social worker that gets appointed, let them advise you what's best for the child after they have listened to both sides of the story. I am very opposed to one parent making sole decisions regarding a child if they have not tried firstly to resolve this matter by discussion with the other parent. The specific scenario is very important to note that had there been a parenting plan in place, they could have gone to a facilitator and the facilitator could have resolved the specific issue. But unfortunately, he is not one, and that's basically the purpose of having a parenting plan, to avoid these problems from happening in the future. So let's move on. Sorry, I don't know that. Okay, let's go further. Can a parenting plan be drafted by an individual who is not a South African and their work permit is still pending? I don't believe that the Pacific parenting plan is dependent upon who drafts it. The law does mention who can draft it. Obviously, lawyers can do it, social workers, family advocates office, etc. But if you are a foreign person without a work permit, I don't think that will invalidate the parenting plan itself. If the parties follow proper procedures, etc., and it's signed and they're happy with it, and the family advocate office is happy with it, I can't see any problems happening there. But that might be a labor issue. The question is, can a person charge for work in South Africa if he doesn't have a permit to work? So the next question is two-pronged. The first one is, can a father take a child from the mother in SA if the father is not a South African citizen? Yes, it's possible. You do not have to be a citizen of South Africa to have custody or guardianship rights over the child. You are the father of the child. You have rights for the child. Obviously, it must be in the child's best interest. So, depends on the facts of the matter, but it is possible. The second question is it illegal to leave your child at home alone in South Africa when you have no means or income to send the child to aftercare? I cannot answer that question. I think it's not in the child's best interest for the child to be alone at home, depending on the child's age, etc. That question would best be posed to a social worker. Obviously, you want the child's best interest to be upheld. And if the mother must go to work and she must be employed and she does not have money for aftercare, that's a very difficult situation. But unfortunately, I wouldn't be able to answer that question from a legal point of view. I would advise a specific person specifically to speak to a social worker for advice on that specific topic. I can't, and hopefully they will give some type of alternative advice. But my quick advice is, please, your child's best interest is of paramount importance, and you wouldn't want to put your child in any possible danger. The next question. So my 4-year-old daughter at the time was living with her father, and she had a speech problem, and he refused to take her for therapy. Long story short, I took him to the children's court to get primary care. I was awarded primary care, and he got visitation rights. And we were instructed to do a parenting plan through my attorney, which he refused to do. He now no longer visits his daughter since the order was in place. He doesn't phone or anything. It's been 11 months since he's seen or even called his daughter. He also does not pay maintenance. I tried to get a passport for holiday for her, and he is just ignoring my emails. I need his consent to do play therapy, and he is not receptive. How do I get his parental rights terminated, as he clearly does not care for his daughter? And she misses him, and I've begged him to call her. I pleaded with his family. We have a court order in place saying he needs to see his child, but doesn't. I can't do a lot of things like go to holiday, etc. Lost out on my job opportunities overseas because I can't get a passport for my daughter. So that is a scenario which we regularly get. It's not something which I think I dealt with something like that maybe like 10 times already, taking it to court level. Here we have a situation whereby the parties went to court. The father did not want to partake in a parenting plan situation, which he has full right to do. The court made an order, gave the child to the mother to have primary care. Obviously, they still have co-custody rights. Now the father is not involved in the child's life. He doesn't pay child maintenance, and he doesn't, visit the child, etc. The mother has a problem. The problem she has is, yes, the father is not involved in the child's life, but she wants to further her life. She wants to go overseas and work overseas. She would like to go on holiday overseas. She requires his consent now and again, but she can't get hold of him or he doesn't give the consent. This is a typical example whereby the specific parent may wish to apply to court for sole guardianship rights over the child. I wouldn't necessarily say terminate his rights of parental rights and responsibilities of care and contact, because he might come back tomorrow, the child wants to see him, and if he does change tomorrow, we can still, have contact with the child, and I'm certain the mother will be happy with that, and the child will be happy with that. But looking at the situation here, I would actually advise the mother to approach the court and ask the court that she can have sole guardianship rights over the child. So when it comes to issues concerning consent issues, traveling overseas, etc., and she needs to motivate it. She must motivate it in the sense of, I've contacted his father many times and he doesn't want to give consent. What can I do? The court might be a bit loath in giving a blanket right of guardianship, whereby the mother can at any point just leave the country without consulting without consulting with the father. But if she can convince the court, saying that this man is nowhere to be found, I can't get hold of him, he doesn't want to get hold of, and should I every 6 months or every year go to the High Court or any court to get consent to visit overseas and cost me X amount of thousands of rands, which is obviously a waste of money? Under those circumstances, she might be able to convince the court that the court can terminate his guardianship rights over the child. The same would apply to schools, etc. medical procedures, and so on. Let's go to the next question. At what age can a child sleep over, and should adequate accommodation be available if the child sleeps over, such as a bed or bedroom? So there is no specific age. I mean, a child can sleep over at the age of, maybe 1 or 2. I mean, obviously a little infant child, you have to consider the needs of a little baby. But my scenario I always apply is, if you and the parent or mother and the father were still living together happily in a relationship, and tomorrow the father most probably has to overnight by his sister or brother for whatever reasons, maybe for something, and you must probably say, no, it's fine, my 2-year-old child can go and overnight with the father there. If that situation applies and you're happy with that while you are together with him, why should the situation be different now that you guys are separated? I always apply that type of logic. But there is no rule specifically stipulating that a child of 2 years old, 3 years old, 4 years old, 5 years old, or 6 years old, then they can only have specific overnight contact with the other parent. There is no rule. But obviously you have to be reasonable and looking at the child's best interest, considering a lot of stuff. If the child was never overnighted by the other parent, then obviously that must be considered. Then you must probably have to just wean it in. Regarding the question having adequate accommodation, some people are wealthy, some people are not wealthy. Some people, they live 4 people in a room, some people live 2 people in a room, 5 people in a room. I'm not here to judge anybody. Everybody's circumstances are different. As long as the child won't be neglected and not exposed to anything bad, if there is not a bed and the child must sleep on the floor and this is the people's standard of living, that is it. Life goes on. Not everybody can afford to have a big mansion or a house with a spare room for the child to come visit every day. But if the child is sleeping with 2 adults and he might be exposed to something not good for him or her, then obviously that's not in the child's best interest. Or should the child live with somebody that's a bit naughty, for example, like a drug addict or somebody that's very drunk, and that will be the specific room where the child will be staying in, and the child will be exposed to some bad things, that would not be in the child's best interest. But it's not a requirement that the child should have a bed and so on in order for the parent to have contact with the child. Sleeping on the floor comfortably, that is also fine. We got 3 more questions. Okay. We are currently separated since 16 July 2020, so that's a few months ago. Ever since school started again, I am only allowed to see my daughter every second weekend if I ask to have my daughter to sleep over by me. During the July-August period, when school was closed, I saw my daughter for a maximum of 5 days at a time, but my wife had her up to 8 days at a time. Me not wanting to jeopardize the little visitation I get from my wife, chose rather to not argue. I am contributing financially every month and also buy whatever my daughter needs when she is by me, example clothes, etc. There's no question over here, but I can resume what the problem is. The problem is the parties were together, they are married, but they separated since 16th of July 2020. And now they have a problem regarding how to share this child. And that's a problem because it was lockdown and the child was with him all the time, for the last 6-7 months. And now all of a sudden they separated, and now the mother believes she's entitled to have the child 8 days at a time, and the father believes he's entitled to have the child also half the time the mother has. This is a perfect situation where the parties will have to enter into a parenting plan. They need to sit down with a professional. They need to sit down with a social worker, whoever the case may be, to assist them. If they cannot come to an agreement regarding this, I advise the father to approach the court. And the case will be solely based upon, historically, that the child was cared by them both for the last 6 months during lockdown, and now they're separated. So his case is actually a bit stronger now based upon lockdown. Second last question, if you have been advised by a therapist that you have a right to approach a court of law to stop the other parent's contact with the child due to child negligence, what is the process? If you were advised and there's a professional document in place and the other parent is adamant they want to have contact with the child, I would advise you to urgently approach the court, children's court or a high court, and have an order put in place dealing with a specific situation. You see, it's difficult to answer these questions in isolation. Doesn't mean that there's an allegation from a therapist or his or her opinion that contact should stop, but is it in a child's best interest for contact to stop completely? Wouldn't supervised contact be possible? Wouldn't contact, limited contact be possible? So that needs to be looked at. So if you are approaching the court, come with a situation, come with a solution on how we can still have a relationship between the father and the child, if that is the case, or the mother and the child, as opposed to this stay in contact. So approach a court would be the best thing to do. And the last question, what steps or advice would you give when child maintenance is not being received? Can a parent who needs to pay child maintenance approach the court for reduction in amount immediately after divorce and before payment of maintenance has even commenced? Now, this is the problem we have. Usually these clauses regarding child maintenance are stipulated in divorce orders where the parties quickly signed it. They signed this documentation for the sake of getting divorced. But what happens is after they divorce, they're no longer married, we have a problem of a divorce order being a maintenance order either being excessive, etc. If you cannot afford it, you are welcome to approach a maintenance court, but you have to convince the court or explain to the court why you have agreed to it a month or two before, and all of a sudden, now you can't afford it. If it's COVID-19, because you lost your job, that is a valid reason. However, you'll have to pass that hurdle. Ladies and gentlemen, thank you very much for your time. If you enjoyed this video, please share it. Please feel free to visit our website, www.ourlawyer.co.za. There are many articles dealing specifically with these issues concerning child custody, child maintenance, guardianship rights, relocation, etc. Written for the layperson. As I mentioned earlier on, our policy is strictly, we don't focus too much on the law and just copy and pasting the law. Our policy and our way of working is to explain the law to you, applicable to your specific situation. So when you leave our consultation or obtain our advice or read our articles, you will be in a better position than you were before that, as opposed to just reading a lot of things, not understanding it, and in no better position. Thank you very much for your time. I hope you have a wonderful weekend and hope to see you at the next webinar. Thank you. Bye-bye.